Welcome to This Explainer. Today we're unpacking a truly gripping 89-page constitutional court judgment out of South Africa. We're talking about a ruling that literally reshaped human rights history. It's the case of the National Coalition for Gay and Lesbian Equality versus the Minister of Justice. And this decision, it struck down an entire web of discriminatory laws and firmly locked in the rights to equality, dignity, and privacy for gay men in a newly democratic South Africa.
All right, let's map out our journey today. We're going to start by looking at the challenged laws themselves, then we'll dive into the rights at stake, put those laws through a constitutional stress test, zoom out for the global context, and finally get to that sweeping final verdict.
Part 1, the challenged laws, setting the stakes. Because, to really grasp the impact of this ruling, we have to look at the specific laws that were put on the constitutional chopping block.
This wasn't just one isolated rule. It was a whole web of legislation targeting gay men. We're talking about a common law ban on intimacy, sure, but it also tangled up with sweeping police powers in the Criminal Procedure Act, literally allowing arrests without warrants and the refusal of bail, and even employment blacklists under the Security Officers Act. Imagine losing your livelihood just for a conviction under these laws.
And then there's Section 20A of the Sexual Offenses Act. This one exposes the sheer absurdity of the system. The court highlighted this startling example. If a gay couple kissed at a party in a way that stimulated sexual passion, boom, they're committing a crime. But a heterosexual or lesbian couple doing the exact same thing at the exact same party, totally legal. The law treated a simple kiss completely differently based entirely on who was doing the kissing.
Moving right along to Part 2, the rights at stake, equality, dignity, and privacy. Let's see how the new South African Constitution fiercely pushed back against all this by protecting 3 fundamental human rights.
First up, the court had to actually pin down what sexual orientation means. They went with a highly precise definition from Professor Ackermann, which centers on erotic attraction. The court made it super clear. Sexual orientation isn't just about what you do, it's a core part of human self-definition. And because of that, it deserves the absolute highest level of constitutional protection.
Here's the really crucial point, though. These laws didn't just stop at banning physical acts behind closed doors. They created this massive toxic ripple effect. The court recognized that they fostered police entrapment, encouraged violence and queer bashing, and drove all this everyday peripheral discrimination, like being denied housing or basic facilities. The collateral damage was huge.
Take a look at this quote. It perfectly grounds all this abstract legal theory into the very real human cost. By labeling a group of people as criminals just for their orientation, the law basically branded them as unapprehended felons. I mean, think about the immense psychological weight of that. Even if you're never actually arrested, just living under laws like this forces you to hide who you are and completely entrenches the stigma.
And that leads us directly into Section 10, the right to dignity. The justices didn't mince words here. They found these laws were a palpable invasion of human dignity. By criminalizing a form of sexual expression that is totally fundamental to the human experience, the legal system was basically telling a huge chunk of the population, hey, you are inherently less worthy. And that is a clear violation.
Which connects seamlessly to Section 14, the right to privacy. The court argued that every single one of us has a right to an inner sanctum, right? A private space to build relationships without outside interference. The government barging into that space to police consensual, harmless intimacy, that's a massive overreach. The state has absolutely no business in the bedrooms of consenting adults.
Part 3, the constitutional stress test, specifically the Ackermann multi-stage inquiry. So, how did the court actually put these laws under the microscope?
Well, they used the Ackermann test. It's basically a step-by-step stress test for any challenged law. Step 1, does the law treat people differently? Step 2, is that difference actually unfair discrimination? And Step 3, if it is unfair, can the government legally justify keeping it around anyway for the so-called greater good of society?
Now, those first 2 steps, they happened in a flash, because the 1996 South African Constitution is actually one of the few in the world that explicitly lists sexual orientation as a protected class. So any discrimination based on that is automatically presumed unfair. Boom! The laws failed the fairness test right out of the gate and the burden flips squarely onto the state.
Which brings us to the climax of this legal drama. We know the laws violate equality, privacy, and dignity. The big question is, could the government offer any valid, justifiable reason to keep these severe limitations active in an open, democratic society?
The court's answer? A resounding no. Justice Ackermann hit the nail on the head here. He forcefully stated that you cannot use the law to enforce societal prejudice or private religious views. You just can't. In a true democracy, one group doesn't get to weaponize the criminal code to force its private morals onto everyone else, especially when absolutely no harm is being done.
Part 4, a global context. Let's look at international trends in decriminalization. Because to really fortify this conclusion, the court didn't just look inward. They zoomed out.
They looked at how other open, democratic societies were handling this, and what they found was a massive, decades-long cascade of momentum. England and Wales decriminalized it back in 1967. The European Court of Human Rights struck down Northern Ireland's laws in '81. Fast forward to 1994. Germany repeals its laws, Australia passes its Human Rights Act. The global tide had well and truly turned.
The court actually made a super interesting, direct comparison with the U.S. here. At the time, the U.S. Supreme Court had upheld similar sodomy laws in a case called Bowers v. Hardwick. But the South African court was like, hang on, our Constitution is fundamentally different. Unlike the U.S. text at the time, South Africa explicitly guaranteed dignity and specifically protected sexual orientation, so they confidently charted their own course.
Ultimately, the international consensus was undeniably clear. Courts across Europe, Canada, Australia, New Zealand, they all recognized the severe psychological harm of these laws and moved to scrap them. The message was loud and clear. Criminalizing private consensual intimacy between adults simply has zero place in a modern democracy.
And that brings us to Part 5, the final verdict, striking down the laws. This is the moment the Constitutional Court delivered its sweeping, historic resolution.
They didn't just tweak the rules a bit, no way. They entirely dismantled this whole web of discriminatory legislation from the top down, unanimously. They struck down the common law offense of sodomy entirely. They tossed out Section 20A, and they ripped the offense right out of the schedules of both the Criminal Procedure Act and the Security Officers Act.
Now, there was a fascinating little legal hurdle that came up regarding non-consensual acts. Some folks argued, hey, if you strike down the sodomy law entirely, aren't you leaving a loophole for male rape? But the court saw right through that. They basically said, we don't need to keep a discriminatory law on the books just for that, because non-consensual acts are already completely punishable under standard neutral laws like assault. The discriminatory core had to go entirely.
This brings up a massive concept, substantive equality. The court realized that true equality isn't just about crossing bad laws off the books. Because gays and lesbians are a vulnerable political minority, meaning they often can't just change laws through voting blocks alone, the Constitution has to step in and actively protect them. As they say, equality delayed is equality denied.
So as we wrap up this explainer, I want to leave you with something to ponder. This 89-page judgment laid an incredibly powerful foundation for human rights, completely redefining the boundaries between state control and human dignity. But if the law cannot dictate the private consensual intimacy of adults here, what other areas of private life are still waiting for our legal systems to catch up? Thanks so much for exploring this fascinating legal landmark with me today.